Miss Barton, and to everybody in court, I'm conscious it's very hot. Are you all surviving?
Yes, thank you, my lady.
I'm really sorry. We have asked for the windows to be opened for tomorrow. Whether that will help, I don't know. But if any of you is in real difficulties, please don't hesitate to say so, and we can see what steps we can adjust. Thank you.
Thank you, my lady. My lady, I'm going to deal with the Crown Prosecution Service ground 1 first. That ground being that the judge was wrong in allowing XGY's appeal against the decision of the circuit judge in that he failed to apply settled law as to the extent of the immunity applying to words spoken by an advocate in court. And that arises in this way. May I take you to the core bundle, tab 13, page 208, which is paragraph 133 of the learned judge's judgment.
Yes.
And he there says at paragraph 133, second sentence, I reject the appellant's submission that advocate's immunity at court only exists as an extension of witness immunity at court. In my judgment, the Supreme Court in Hall swept away advocate's immunity at court only in relation to civil claims by clients.
Yes.
And we respectfully submit that is correct.
Yep.
But what then happened is he failed to recognise the inevitable effect of that conclusion, which was that it was fatal to all claims against the Crown Prosecution Service and that the action had therefore to be struck out. Now, in order to make that ground good, I obviously have to establish the nature and extent of the immunity that he was talking about. And may I start, my lady, by going to the case of Munster and Lamb, which is volume 1, tab 6, page 89.
Yes.
That was an action brought in defamation against a solicitor for words spoken by him before the court whilst he was acting as an advocate for a person charged in criminal proceedings. So it is a true advocate immunity case. The court considered the separate and distinct positions of a judge, witness and advocate in judicial proceedings. May I ask you to go to page 100, please?
Yes.
There we see the nature of the action in the paragraph beginning this action, and I've just indicated to the court the nature of the action.
And we read that this morning, I think.
You have. And in that passage, the court was there saying that even if the words are irrelevant to every issue, if the words are uttered with reference to and in the course of a judicial inquiry, the immunity will attach. At page 102, the court considered the immunity which applies to witnesses. At the bottom of the page, with regard to witnesses, the chief cases are. And the reason I draw that up at this stage, Mary, is because there is clearly a distinction to be made between the immunity which attaches to witnesses and evidence and to the extent of the immunity which actually applies beyond witnesses. And we go there to page 105, where the court there considers the position of judges and advocates and says this, about a third of the way down the page, beginning for more than a judge. Can I ask you to read down to the sentence which ends with and misconduct?
Yes.
We there see one of the rationales for the immunity, namely that those who are acting bona fide must be protected from having to be troubled by litigation which arises out of what was said or done in court. Over the page, if we may, to page 106, the then Master of the Rolls dealt with the rule being founded upon public policy, and if we begin with the sentence which begins, with regard to counsel, the questions of malice, bona fides and relevancy cannot be raised. The only question is whether what is complained of has been said in the course of the administration of the law. If that be so, the case against a counsel must be stopped at once. No action of any kind, no criminal prosecution can be maintained against a defendant when it is established that the words complained of were uttered by him as counsel in the course of a judicial inquiry. That is an inquiry before any court of justice into any matter concerning the administration of the law. And we respectfully submit that that encompasses why the immunity brings an end to the claim in this case against the Crown Prosecution Service. Further assistance on the rationale is to be found at page 108. And may I ask that you read the red line section?
Yes, thank you.
Thank you.
Yes.
And we would submit that that passage makes it clear that the justificationism approach taken by the learned judge was simply wrong. May I then take you to the authority of Marinan and
But his point was, I think, his point was that things have moved on.
They have, my lady, but not to the extent of undermining those core principles or the rationale. Insofar as they have moved on, we will see it in the post-1999 authorities, which is Arthur J.S. Hall and also Jones and Caney. But they relate to a very distinct limitation. They do not attack the underlying rationale. And so, if I may take you then to the case of Marinan and Vibart, which is at tab 8, volume 1, tab 8, page 121. Marinan concerned actions of police officers in compiling a report and giving evidence in proceedings against a disbarred barrister. The case at its heart was about the immunity of witnesses. However, the court examined the wider impact of the immunity and the rationale which underpinned it. And this case is of assistance when my lady raised the question of where did the phrase "in connection with" come from. And if one goes to page 124 of this judgment, we can see halfway down the page a sentence beginning, "It has been extended within a limited field," to statements made outside court in connection with an action.
Sorry, where are we?
We're about halfway down the page, my lady. In the middle of the page, we see it's
Yes,
true that an action to recover damages...
And these are the submissions for the plaintiff rather than the judgment.
Yes. But it's been extended and it says in connection with an action. So that is a judgment, in authority in which there is reference to in connection with.
I think my Lord Justice Coulson pointed out that it may have come from Smeaton.
I think at Smeaton it's at paragraph 35, that's tab 16, page 315.
Thank you.
And there is another reference, as we are on the subject of in connection with, at Iqbal, tab 33, at para 70, 871, and para 82 at 876.
Thank you. Thank you.
So back to the case of Marinan in terms of establishing the nature and extent of the immunity. At page 126, if I may go there. Lord Justice Sellers there said, this action is in my view misconceived. Those who take part in the administration of justice, and it is one of the important functions of police office to obtain and bring evidence before the court, must be free from the fear of civil proceedings. So what one takes in our submission from this case is that the scope of the immunity extends to those who take part in the administration of justice. And I pause there to emphasise that counsel are unarguably involved in the administration of justice when they are speaking in court on a bail application in the way that happened in this case. Page 128, and I regret that this hasn't been red-lined, my lady, but it should have been. The paragraph beginning, it has been sought in this case.
Yes, it's the second sentence.
Yes,
third sentence, sorry.
Yes, it is. And a point which is important in this third sentence is not only in respect of causes of action, which are limited, but in the way that this sentence makes a distinction between evidence and what is said and done in the course of judicial proceedings. Because the beginning of it relates to actions which are sought to be derived from what was said or done in the course of judicial proceedings, which must suffer the same fate of being barred by the rule which protects witnesses. So it's not a rule that protects witnesses or evidence only, it's a rule which clearly extends beyond that to what was said or done in the course of the judicial proceedings. I don't think I need to take the court to this particular reference, but for your note, at page 131, the court specifically considered the nature of the claim, whether the nature of the claim made any difference to the existence of the immunity, and concluded that it did not. The next case which I would have taken you to, but I don't intend to because it's been covered in detail by my learned friend, is Taylor and the Serious Fraud Office. It was already covered in detail, and I don't need to go to the detail of it, save that I do ask you to look at one important passage in the speech of Lord Hoffman, which is at page 257.
Yes.
And it is there at F, where Lord Hoffman says, by the end of the 19th century, it was settled that persons taking part in a trial, the judge, the advocates, the witnesses, could not be sued for anything written or spoken in the course of the proceedings. And we submit that the Crown Prosecution Service falls squarely within that definition of the immunity. There are two aspects of Taylor which Mr. Beer did not go to because he left them to me, and they are the elements of the judgment which consider the rationale which sits behind the immunity. And this is important because it's, as my lady said, the learned judge was misled himself by saying, well, there have been changes to the immunity, but there haven't been changes to the rationale. And one can see, if one goes to 258E, that the rationale which I raised in the earlier case follows through. 258. The immunity from suit, if I can just ask you to read to yourself paragraph E.
What does it mean it's not concerned with its use for any purpose other than as a cause of action?
I think it means that the immunity attaches to the circumstances in which the statement or evidence was given. It isn't concerned with how it's used. It's about the circumstances in which it arose.
I mean, in the earlier cases, Marin and Vibart, and the other cases, Watson and McEwen, it's clear that underlying all this is the public policy
Yes.
involved in protecting the administration of justice.
Yes.
And freedom of people being free to speak, in particular witnesses, advocates and so on, is an aspect of that.
Yes. Yes, it is. A further aspect, which Malone and Friend has already gone to, is the need for a person to know at the time he speaks whether the immunity will attach or not. And that's at 264E2F. I don't need to take you there.
That was the passage we've already looked
Yes,
at.
exactly.
That you need to know at the time, not afterwards.
My learned juniors helpfully handed me a note that says, in terms of it's not concerned with its use for any purpose other than as a cause of action, it's a contract with an implied undertaking, which was the other ground in Taylor.
Yep.
So turning then to the position as at the time of Taylor, it was settled law, as Lord Hoffman recognised, that judges, advocates, witnesses couldn't be sued for anything written or spoken. To what extent have the more recent authorities changed that position? Well, Arthur J.S. Hall, the decision of the House of Lords in 2000, which is in Volume 1, Tab 19 at 435, undoubtedly limited the extent of an advocate's immunity, but only insofar as the claim is a negligence claim by a client against his own advocate. If we go to page 443, at BC, the court there dealt, Lord Hoffman, with the nature and extent of the immunity which protects witnesses, lawyers and the judge. And it made very clear the point which my lady just made clear, which is that this is about the administration of justice and the need to speak freely. So by the time we get to Arthur J.S. Hall, even though the immunity limitation is put on it in respect of negligence by a client against his own advocate, the rationale which underpinned the immunity for centuries held good. It was simply that, as my learned friend said in argument earlier this morning, each time the court looks at an immunity case, they will look at the greater public policy, not the justification in a particular case, but whether certainly in the higher courts, whether the public policy which underpins the immunity still justifies the continuation of that immunity in the same court. the court there in Arthur J. Hall was considering the extent to which the immunity was necessary in proceedings for negligence to enable advocates to conduct litigation effectively. And I don't think I need to take you to the particular paragraphs, but I'll give you the reference. Lord Hoffman at 453 referred to what he called a well-established rule that witnesses, judge, counsel and the parties are all absolutely immune from liability for anything said in court. And at 467, Lord Hope described the immunity as the immunity which attaches to the advocate when engaged in conduct performed in court from claims by his client for negligence. And that's the immunity that they were looking at. At page 480, and I think we do need to go to this in light of Mr. Justice Ritchie's conclusions, the bottom of page 480 at H, Lord Hope expressed the view that the core immunity still had a legitimate aim in civil cases, but that it was no longer necessary in cases where the advocate's immunity extended to claims against by his client for claims of negligence. So it's clear that the restriction on the immunity is limited to a claim of that nature and is not intended to be any wider. We then turn to the case of Darker, which is in volume 1, tab 17, page 316, which in fact was reported before but decided shortly after Arthur J.S. Hall. This case concerned the scope of the immunity and in particular whether it extended to things done by the police during the investigative process, which could not fairly be said to be part of their participation in the process as a witness. What I think it's necessary to establish in our submission is what was said by Lord Hope at 326H. Which is the starting point for the immunity. This immunity, which is regarded as necessary in the interest of the administration of justice and is granted as a matter of public policy. So there he's establishing the nature of that immunity, and at C says no challenge is made in this case to what may conveniently be described as the core immunity. What was being looked at in Darker was the extent to which the conduct of the police could be said to fall outside the immunity because it did not fall within that definition. Now, of course, the conduct in Darker was particularly egregious and concerned the fabrication of evidence. And so we have a case where it's at the extreme in terms of the preparation of material for court. And so in terms of the starting point for the consideration of the scope of the immunity in Darker, what that court called the core immunity was not in dispute. The court recognised that the immunity had been established for centuries, and in essence the discussion in Darker was confined to witness immunity for acts outside court, not to the immunity which attaches to others who are entitled to it, such as judges, jurors, witnesses, or parties themselves and advocates. terms of the further development, there is then a very helpful case of Medcalf and Mardell, where there is a clear explanation of the rationale for the immunity. That is at Volume 1, Tab 20, 531. That case concerned a claim to recover the costs of rebutting serious allegations made by counsel for the claimant's opponents in civil proceedings, and is a case concerning advocates' immunity. Paragraphs 51 to 54 of the judgment contain a helpful summary of the rationale for the immunity. May I take you to page 531E? Starting with the constitutional aspect, and may I ask you to read to the end of paragraph 54, perhaps the second sentence of paragraph 54, so at D on the next page.
Yes.
So there we see that although there have been some has been some erosion of the immunity in terms of negligence claims, the rationale for the immunity remains firm and consistent throughout the examination of the authorities. If I may then take you to Jones and Caney, which is at tab 26, page, volume 2, tab 26, 672. Jones and Caney was a case which again ultimately restricted the operation of the immunity. It concerned the immunity of an expert witness for acts done pre-hearing in connection with the evidence they intended to give. The immunity from suit for breach of duty which expert witnesses had enjoyed was abolished. And so it is analogous, we would submit, to the Arthur J. Hall case. If one goes, however, to page 682,
Yes.
and there the court made clear that an advocate's still protected by absolute privilege from a claim in defamation in relation to statements made in the course of the conduct of legal proceedings, and they refer back to Medcalf and Mardell. And in terms of that, we would submit that it's clear from the authorities, and I'll come back to it in a summary in due course, that, of course, the immunity is not restricted to defamation. It arises frequently in the context of defamation, but there are numerous other claims to which it can attach, because the rationale is equally applicable to those causes of action. Now, there are 3 modern cases in the High Court which considered the historical development of the immunity in the way that I have just done, and which were considered by the learned judge in the course of his judgment. The judge wrongly, in the CPS submission, considered he could distinguish these cases. And just for your note, and I will take you to the specifics if necessary, at paragraphs 102 to 104 of his judgment, which is in the core bundle, tab 13 at 195, the judge there dealt with the way in which he thought he could distinguish these cases. The first of them is A and B and the Chief Constable of Hampshire.
And are we going to be helped by looking at them in this court?
Unless you wish me to take you to them, I think the short answer is no, because what they do is they reiterate the immunity which has been well established by that time, and they simply apply it to the particular facts of the case. One case which might be of interest to you on the facts and of assistance is A and B and the Chief Constable, because that claim concerned the liability of police to informants. And during the course of a public hearing, counsel disclosed that the police had relied on information from an informant, and it was alleged that the information given in court and in documents submitted in later PII proceedings enabled jigsaw identification of A as the informant. So in terms of the facts, it might be of some assistance. It's at page 784. The other reason it's of assistance in passing is because it's a strikeout case, and so as in common with a number of these, it also shows that these sort of cases are absolutely suitable for strikeout.
CPS weren't a defendant.
Sorry?
The CPS weren't a defendant.
No, they weren't, but the Chief Constable was,
Yes,
and
no,
it
I
was,
got
of
that.
course, there. If one takes the argument of the respondents in this case, they are further removed from the centre of the immunity than the CPS are.
Yeah.
Mr. Justice Ritchie sought to distinguish the case at paragraph 102 on the basis that disclosure was in evidence disclosed before the hearing and evidence summarised by counsel at the hearing. And we would say there's no possible basis for that analysis. Counsel wasn't giving evidence. The information disclosed had nothing to do with the evidence in the criminal proceedings against X, who is in fact facing a charge of armed robbery. The claim in fact rested upon a disclosure by the prosecutor at court in relation to the involvement and status of A. And in fact, far from being distinguished, A and B is on all fours with the present case insofar as the police are concerned. If one goes to page
But the disclosures allegedly committed by the police failed for reasons unconnected with immunity.
They did.
Yeah.
Yes. If the court thinks it's not particularly helpful, I can move on.
No, you say headline point. The judge below was wrong to distinguish A and B on the facts.
On the facts. And just for your note, at paragraph 33 of A and B, it's not the giving of evidence which attracts immunity, it is the circumstances surrounding the court proceedings and the need for advocates to be able to speak freely. King and Stiefel, which is volume 3, tab 44, 1347, again, a strikeout case, a claim against an advocate but not by his own client. Mr. Justice Ritchie held at paragraph 103 of his judgment that the allegations against the advocate arose out of his 5-day cross-examination of the claimants in previous proceedings and were thereby connected to evidence. Again, this is wrong. The claim was based on 3 things. 1, an alleged common design as to the litigation strategy, which is at page 1379 and 1381. The position that counsel had advanced on costs, which is at paragraph 1566 at page 1380, and the position advanced in a mediation position statement, which is at paragraph 173, Roman numerals 2 at 1384. And
Could you give me those references
yes,
again?
of course, my lady. The first reference is
No, it's the last one.
the last one. The position advanced in a mediation position statement, paragraph 1732, which is at page 1384. And I do not need to take you to the analysis, which covers much of the same ground as I've already covered. But suffice to say that the conclusion at paragraph 335 of the King and Stiefel judgment, which is at page 1412, is that having applied the correct test, namely whether all the matters complained of had been done in the ordinary course of proceedings, the conclusion was that all allegations relating to Mr. Downs' conduct in court fell to be struck out. And then the last decision which Mr Justice Ritchie sought to distinguish was the Al Haddad and Al Rostan Mani, which is volume 4, tab 49 at 1551. The claimant alleged in that case that solicitors and counsel had dishonestly misled the court in an earlier case, thereby procuring judgment by fraud. Mr Justice Ritchie didn't make any attempt to analyse the facts in order to distinguish the case. In fact, at paragraph 104 of his judgment, which is at page C13195, he accepted that if the immunity applies, then it's an absolute bar. But he said that then that begged the question in the appeal and didn't find the authority helpful. In fact, the issue of whether the immunity applies to the Crown Prosecution Service on the facts of this case is, we would submit, very simple to determine, and Al Haddad is a useful recent authority on the effect of the immunity as a bar to proceedings. Al Haddad, Mr Justice Fancourt examined the authorities on immunity at paragraphs 76 to 96. And may I just draw your attention to this one, we would say, important facet of the judgment. At paragraph 86, page 1575 of the bundle, Mr Justice Fancourt said the immunity operates not as a defence to an action but as a threshold immunity which operates to prevent a protected person, including a legal representative, from having to deal with a claim at all. And so again we would submit that that undermines the way in which Mr Justice Ritchie approached his judgment with this justification for the existence of the immunity.
Your submission is that each of these authorities was an application of well-settled
Yes,
principles.
yes, on the basis of a rationale which has been considered at the highest level and has not been interfered with, save in respect of own client immunity for not just decades but hundreds of years.
And that brings us to paragraph 42 of your written skeleton.
It does. Paragraph 42, my lady, sets out a number of factors which can be drawn from the cases. I don't propose, therefore, to take you through the cases, but I do propose to give you the references which, in those cases, will, in our submission, support the assertions that are made in that paragraph. So, taking the first of those, the immunity bars any cause of action based on things said or done by an advocate in the course of proceedings. We would say that that can be derived from Taylor at page 257F, Darker at page 326H to 327B, A and B at pages 789 to 791, King at 1409 to 1412, and CLG at page 35. In terms of extending so far as practically necessary to avoid it being outflanked, there is helpful dicta to that effect in Marinan at page 131 and at Darker at 345 F2H. The fact that it does not simply apply to defamation claims, I've endeavoured to pick up as I've gone through the authorities, but it does apply to all causes of action, including claims under statute, and I pause there to say, of course, we acknowledge that it does not apply to the malicious abuse of process torts, which require not just malice, but a lack of reasonable and probable cause, which is an essential element, and which is why Gisonio failed on the facts, because they'd sought to circumvent that the absence of reasonable and probable cause element by pleading misfeasance, which does not require that. So, dealing with the all causes of action point, Marinan at page 131, at Darker at 326H to 327B, Crawford at 844 G2H, King and Stiefel at 1411. The abolition of the immunity of advocates against claims by a client for negligent conduct, I've covered. I don't think I need to give you further references to that. Advocates still attract immunity from claims arising from information disclosed or things said in court, and that's King at 1409 to 1412, A and B at 790 to 791, and Al Haddad at 1579. And although this is not an issue in this case, just for completeness, the rule protects those who are malicious and dishonest in order to fulfil the rationale which we've gone through. Taylor at 257F, A and B at 791, and Al Haddad at 1579 to 1580. In my submission, the an examination of the authorities that has just been conducted makes good our submission in ground one, which is that the judge failed to follow the clear line of authority. And in my respectful submission, there is little point dissecting further than my learned friend has already sought to do the judgment, because it is so clear that in reaching the decision he did in the face of the authorities that are so well established, he has clearly misdirected himself. Ground two.
Anything on ground one? Anything on ground one? No. Yes.
Ground two, my lady, is that the judge was wrong in allowing the appeal against the circuit judge, in that he wasn't entitled to overturn her decision that the issue was suitable for determination as a strikeout. In essence, the issue is whether an immunity, whether the issue of whether an immunity applies is suitable for determination on a strikeout application. And given the rationale which sits behind the immunity, that we would submit that it should be determined on a strikeout application. Otherwise, the whole rationale for the immunity is undermined, because it requires those who are defending it to take time and effort defending an action which will otherwise fail. So,
well, if Mr. Justice Fancourt is right, that was the point he was making in Al Haddad.
Absolutely.
That it's a threshold immunity. So
yes.
If that's right, then it is the sort of thing that should be determined on a strikeout.
Absolutely, yes. It would also undermine the important point which others may pick up, but the requirement that a person knows when words are spoken and acts done whether the immunity applies. There has to be certainty for this immunity to work. So unless I can assist further on ground two, the third ground of appeal is that in light of grounds 1 and 2, the judge was wrong to set aside the decision to strike out the claims for misuse of private information and the other remaining claims, because the question is, does this immunity apply to all causes of action? And the answer to that, if one looks at the authorities, is a resounding yes, because of the nature of the rationale which sits behind the immunity. It would be nonsensical, given the rationale, if one could use a bit of lateral thinking and come up with different ways of pleading the same facts, which are essentially what was said and done in court, insofar as any cause of action, however novel it may be, or well thought out, relies on, as its foundation, what was said or done in court. It must fail. And that is a thread that has run through, with the exception, as I say, of the two restrictions on the immunity in Arthur J. Hall and Jones and Keeney. I don't think, unless it would assist the court, that it's necessary for me to go back to the authorities pointing out the very paragraphs where it says whatever form of action or whatever novel pleading. I've taken you to them insofar as I consider they're helpful to you. So unless I can add to those, I don't propose to take up the court's time doing so.
The main cases are Pearson, No, Crawford.
Well, we can go back as far as Marinan,
That's right, Marinan.
Gisonio, Taylor, Jones and Caney.
And the word ingenious is
Crawford.
used from time to time.
Sorry?
The word ingenious is used from
Yes.
time to time, and
Yes.
that's the...
It is. And as you say, my lady, Crawford. That takes me to ground 4, which is going to be dealt with by my learned junior, Mr. Goss, unless I can assist on any specifics.
I think. Thank you very much. You set it out very clearly as
Thank
well.
you.
That's very helpful. Thank you. Mr. Goss.
My ladies, my lord, I'm going to take ground 4, which equates to the Chief Constable's ground 5, on which my learned friend, Ms. Wolfe, addressed you before the short adjournment. And could I start by saying that I adopt and endorse her submissions on why Her Honour Judge Brownhill was right to conclude that XGY had no real prospect of successfully establishing that the police or the CPS knew or ought to have known of a real and immediate risk to life, all of conduct breaching Article 3, and why Mr. Justice Ritchie's conclusion that this element of the claim was arguable, as he put it, was wrong. I want to address this ground by reference to whether Mr. Justice Ritchie was in fact entitled to overturn or interfere with the circuit judge's decision at all, and in my submission he was not. And should simply have left that decision undisturbed. The starting point is that when considering an appeal, as he was, against an evaluative decision, such as a summary judgment finding, the appeal court's task is, in my submission, to assess that evaluative judgment, and it shouldn't interfere with it, absent an error of law, or the decision being one which no reasonable judge could have reached. In other words, the question for the appellate court is not one of mere disagreement or the fact that it would not have reached the same decision. And that is how the judge himself set out the framework at paragraphs 14 to 17 of his decision, page 146 of the core bundle.
Yes.
And I'd ask your ladyships and your lordship to note in particular what he sets out paragraph 16, where the late Master of the Rolls, he cites the late Master of the Rolls in Clearway, where what is the gateway, if you like, for a appellate court to be able to interfere is that there must be something in the nature of an error of principle or something wholly omitted or wrongly taken into account, or a balancing of factors which is obviously untenable. And that was consistent in my submission. And I should say, as my learned friend Ms. Wolfe referred the court to, the last sentence of paragraph 17, the judge expressly said that that was the threshold he was applying. And that was consistent then with what he said at paragraph 61 and 65 on pages 162 and 163.
It may not matter. The sort of case management decisions that Lord Justice Chadwick was talking about in Royal and Son are procedural decisions.
Yes.
Really procedural. You can get that from, I can't remember exactly what was going on in that case, but we can see from paragraph 37 of that judgment what they must have involved. So is this really apt for strikeout on immunity / summary judgment on immunity cases?
This, of course, was freestanding from an immunity question.
Yeah, well, the victim status point.
Yes.
Yeah.
We say that because what the circuit judge did was an evaluative decision, it may not equate directly to a case management decision, but it's an evaluative decision to which the same principles apply. We can take that from the Oldie Stores case, which is in the authorities bundle, the relevant passage at 591, tab 23. It starts on
Just give me that reference again, Albany Stores, tab.
Tab 23, my lord.
Yep. Page.
577 is the start, and then the relevant passage is redlined on page 5.
That's volume 1, no, volume 2.
Yes, volume 2.
Yes, let's have a look at that.
591, forgive me, my lord, my ladies. Yes, redlined passage, paragraph 16 on page 591.
591. So, Aldi stores strike out for abuse of process.
Yes, but again, it is an evaluative decision that they are dealing with there. So not a case management decision of the sort that your ladyship has referred to, but an evaluative decision that involves looking at the material before the court, weighing the different factors, carrying out an exercise of forming a judgment. And we say that that is akin to what is done on a summary judgment application, where the first instance court forms an evaluative judgment of the prospects of success.
Yes.
And that was the way it was put in the police and CPS submissions to Mr. Justice Ritchie, as recorded on page 162 and 163 of the core bundle, paragraph 61 and 65. '61 in the entirety, 65 penultimate sentence. My own friend Miss Wolfe has already set out why the circuit judge, in her judgment, had set out a careful consideration of the factors relating to real and immediate risk, which the CPS and the police knew or ought to have known of, based on the facts of the Epsom and Hampshire disclosures. I don't intend to go back over those by reference to her judgment, my lady, save to note that obviously those factors included the risk posed by DYP based on the threats and his prior conduct. That included the threat to come through a relative's house, which he knew the address of, and make use of acid. But it also included the fact that there was no evidence of any repetition of those threats after or any attempt to carry out those threats after the arrest on the 7th of November, including in the period where DYP knew where XGY was living, and of course he knew where her relatives were throughout. And HHJ Brownhill's evaluation of those factors was that the risk following the disclosure in April 2020 did not objectively cross the threshold of being real and immediate, such that XGY couldn't have victim status for the purpose of HRA claims relating to the Hampshire disclosure. And in reaching that view, she expressly took account of the claimant being, of XGY, being brought to the fore of DYP's mind by the further allegation in April 2020. Mr. Justice Ritchie, at paragraph 120 onwards, in my submission, despite having set out that he was going to apply a higher threshold appropriately, did not then apply that approach. Instead, his approach was one, in my submission, of simple disagreement. There is nowhere in his reasoning from 120 onwards where he sets out what he says the error of law or principle was that would entitle him to remake the decision. He essentially goes straight into rebalancing the factors for himself as though he were determining it at first instance. He never returns to that approach, he never refers to that approach that he set out at 14 to 17 of the judgment. He's never explained how he applied that to the facts of this case. or whether or not he accepted the police and CPS submissions as to the approach to take that I took you to a moment ago. And in my submission, that approach was an error because there was, in fact, no error of law in one of Judge Brownhill's decision. And so it should never have reached the stage of him looking afresh at the merits of the decision to determine it for himself. Doing the best that one can, there are three possible errors that he may be hinting at best, in his judgment, but in my submission, none of them, in fact, holds good. The first is at paragraph 124 on page 205, my lady.
Yes.
And this is where he refers to the circuit judge's self-direction on real and immediate. And he says that she applied what she described as a very high threshold, relying on Osman and Van Colley. And he then refers to the passage from Lord Bingham that he sets out there, talking of the test for real and immediate effectively needing no judicial exegesis and being a constant. The difficulty with that in my submission is that the circuit judge had dealt expressly with that issue in her judgment at page 327 of the core bundle, paragraph 113. She says, in Van Colley it was explained at paragraph 67 that the facts must be examined objectively at the time of the existence of the threat, and at paragraph 116 that it was made clear that the Osman test, quote, is a constant to be applied whatever the particular circumstances of the case. So if that was a hint in Mr. Justice Ritchie's decision that the judge had gone wrong by not treating it as a constant, he doesn't appear to have taken into account that that is exactly what she said she was doing. It also appears to imply that Mr. Justice Ritchie didn't regard the real and immediate test as imposing a high threshold. And although that is a description...
A very high threshold.
A very high threshold. Although that is a description and not an element of the test, it is one which has been consistently used. And if I could take the court briefly to Van Colley itself, which is in the authorities bundle, volume 2, tab 24 and page 642.
Sorry, give me the reference again.
Yes, volume 2, my lord, tab 24, passage on page 642.
Thank you.
This is from the judgment of Lord Hope, first sentence of paragraph 69. The case was, however, pleaded in a way that sought to escape from the very high threshold that was laid down in Osman. And then again on page 653 in the judgment of Lord Brown. And paragraph 115. The test set by the European Court of Human Rights in Osman and repeatedly since applied for establishing a violation of the positive obligation arising under Article 2 to protect someone from a real and immediate risk to his life is clearly a stringent one which will not easily be satisfied. And so if I am right that when the judge was criticising, it seems, the circuit judge for treating it as a very high threshold, not only is that not a fair description of what she was doing because she made clear that she knew it was a constant test, which is what the point that is made when Lord Bingham says it doesn't need judicial exegesis, it is what it says. but also because it seems to suggest that he thought it wasn't a very high or stringent test to meet, which would in turn be wrong. The second point is that he took the view that the circuit judge was wrong to reach a decision on summary judgment given the position as regards disclosure. My learned friend Ms Wolfe has covered this, so I'll take it quite briefly. We say that this was simple disagreement, not the sort of error that would have entitled him to remake the decision. Again, my learned friend Ms Wolfe has taken you to the relevant passage in the circuit judge's judgment, but we say that that was the sort of case management decision in which a first instance judge should be given considerable latitude, my lady. It's a decision about disclosure and about what steps could or should have been taken prior to the hearing of the applications. And the circuit judge considered the timeline of the proceedings in reaching her view that if further disclosure was necessary for the applications to be dealt with, it ought to have been sought and noted that it hadn't prevented XGY from pleading and putting her case. And that was, in my submission, a robust but fair case management decision of the sort that considerable leeway should be given to. It's within the discretion of a circuit judge to form a view that if a party wants to raise an issue such as that, it's incumbent on them to take steps to address the position well in advance of the hearing, rather than simply sit back. And so we say that the circuit judge was entitled to reach the decision she did in respect of disclosure, and was then entitled to carry that forward into her consideration of the summary judgment application. And that's particularly in the light of the emphasis in the authority's easy air principle 7 of not falling into the trap of speculating about what might turn up. And so to go behind that conclusion on disclosure, in my view, it was incumbent on Mr. Justice Ritchie again to find some form of error of law in the reasoning, but he didn't do so, other than finding it was disproportionately strict. Well, in my submission, that is wrong. It was not disproportionately strict. It was a robust but fair case management decision within the ambit of the circuit judge.
And which paragraph of the judgment, that's to say Mr. Justice Ritchie's judgment, do you say this point goes to, the disclosure point?
So he, at paragraph 120, he refers to what the judge did not have available to her.
I see. So you're extrapolating from that
Yes.
to then go back to what the judge said about disclosure and lack of applications and
Yes.
so on. Yeah.
And then at paragraph 135, my lord, on page 208, he refers to the judge being wrong and disproportionately strict when criticising the appellant to fail to apply for disclosure.
But he also refers to it at 125.
Yeah.
Yes. But we say that is, in effect, falling into the trap of speculating about what might turn up in the light of a prior decision on whether there was sufficient evidence for these applications to be properly heard and determined. There is one other point on disclosure, which is what the judge seemed to think the issue went to, and it's the final sentence of paragraph 120.
Yes.
Which is that the judge appears here to have turned his mind to the question of whether the disclosure would have helped to illuminate the issue of actual risk, rather than what the CPS or the police knew or ought to have known. And he does then go on in the following paragraph to make repeated references to what the police knew, but he never deals with what the CPS knew or ought to have known. And without that element of analysis, we say his conclusions, certainly as regards the CPS, are flawed. The other side of that coin, of course, is that the police were the sole possible source of information for the CPS. And so if the claim against the police fails on this basis, then so too must the claim against the CPS. The last point where one can perhaps identify an error of law that Mr. Justice Ritchie was alluding to or hinting at is in paragraph 122, where he refers to nothing being said in the judgment on the assertion about the mental suffering claimed by the appellant as the result of the breaches. And again, on one reading of that, that could be a suggestion that there was a factor that had not been taken into account. But there are two reasons why that is flawed. Firstly, again, as Ms Wolfe took you to already, the circuit judge did consider the subjective fears of XGY, but did not consider that they translated to an objective risk. Secondly, in any event, the judge was here considering the issue of Article 2 and 3 and victim status for those purposes, and they require an objectively verified risk, real meaning objectively verified, immediate meaning present and continuing, risk to life or of treatment engaging Article 3, which everyone agreed was at treatment at ABH level or above. And so mental suffering in this context, the context of harm from a third party, is not sufficient. There might be other cases, for example, if one was looking at a case of self-harm or risk of self-harm, where that would be a much more pertinent factor, but in a third-party harm case, the judge essentially took his eye off the ball at this point and departed from considering the question of victim status for Articles 2 and 3.
Is there law on that, on the fact that the level of actual bodily harm means that mental suffering cannot be enough?
I think that is a point I'd have to come back to your ladyship on, if I may. Conscious we're coming up to the point for a short break in any event. If I could put a marker down on that one and come back to it.
Thank you.
What I would say is that it doesn't, of course, cross the bar for Article 2 in any event.
No.
But we say that if the judge regarded this as a failure to take into account relevant factors type error, he was wrong to do so because it was taken into account. It doesn't open the door for him to remake the decision. And so when one looks at his conclusions at paragraph 135 on this ground, the factors that he set out as having been, in his words, effectively overlooked were in fact either factors that were properly taken into account or were ones which did not bear the weight that he sought to put on them. And those have already been addressed by my learned friend. But ultimately, when one looks at the approach he took to this decision, we say that it was him expressing bare disagreement with the circuit judge and weighting the factors for himself, rather than properly considering whether the decision was so plainly wrong it was outside the ambit of her discretion, or the fact that simply because he was of a different view, it did not necessarily entitle him to overturn her decision. And so we say that in the event that the immunity doesn't bar the claims under the HRA, the circuit judge's alternative finding of reverse summary judgment ought to be restored. My lady, it's 3:10. I wonder if that's a convenient moment, and I can then perhaps come back very briefly after a short break on the point that you have raised.
I think, yes, certainly, but I think what we'll do when we do have a break now, it is very hot, that you can quickly give us the reference if there is one, and we'll go straight into Mr. Waterman.
Yes.
Would you just, thank you very much indeed, Mr. Goss, very helpful indeed. Yes, any questions?
Thank you very much.
Thank you. Just please do sit down. Do you want to, we can finish up. I'm very hot. Do you want to do 45 minutes, Mr. Waterman? Do we want to do a finishing? Yes, we'll come back. Let's see how it goes. Yes. Okay, just one timing. You happy to 10 minutes and then we'll sit till 4:15? Mr. Waterman, we're very conscious that both you and your learned junior have come at short notice. Thank you for that. And we've seen the draft timetable. If it were possible to plough through, that sounds very negative. If you had an hour, would you finish today and then not come back tomorrow? Would that save time and money? Is my thinking, or would you in any event want to be back here tomorrow, given the nature?
I don't think it will save that much money given the basis upon which we appear, but it certainly may save time, and it may help Ms. Collier and me in other matters we have to deal with. So we will endeavour to...
But if we have a 10-minute break now...
Finish within the window.
Yes, see how we go. Thank you very much indeed. 10 minutes, 3:25.
Okay. Must have done. I know I was there. Yeah, I did then. Yeah. But I left these questions at the end. I let Amy and chair those because I mean they're running it now. So as you weren't there. Challenging the some pieces. It will be at some point, right? I've got to read which sex matter, it's dealing with it, Wetlands. With me and Bob. And on the other side, I don't know who counsel are, because sex matters do quite a lot of their own stuff. But they will get counselling. It is, yeah. I don't know which side of the argument. Sex matters are purely biological. Which J happy with, because these themselves surgery and suicide. I'm not sure. It's interesting, but I think the Home Office are getting into it. Oh, I am. John Riddle.
Yes, Mr. Goss.
Hi, lady, if I could just give that reference, which is the case of SZR and Blackburn and Darwin Council. It is in the authorities bundle at page tab 50, so I think volume 3.
Yes.
And page 1611, which refers to ABH or intense physical or mental suffering.
Intense physical
Yes.
or mental.
And
Mental suffering can be enough.
Subject
That
to a
doesn't
meeting is
surprise me,
sufficient.
but it's got to be intense.
Yes. And could I also just take the opportunity to correct one point which my own friend Miss Murphy has pointed out, which is that it's not agreed that ABH was the relevant threshold. I'm afraid I'd taken that from the position she had advanced that's recorded in the Circuit Judge's judgment at paragraph 118, but I'm very happy to correct that position.
Thank you very much indeed. No, thank you, Mr. Goss. Right, Mr. Waterman.
Well then, may it please you, my ladies and my lord. The Bar Council's submissions will be focused more narrowly upon advocate immunity. That's not only in the interests of economy, but because, as now named advocate immunity as opposed to barristers or counsel immunity, it's a more accurate description because it really is about what is said or perhaps done in court in advocacy. And when the penumbral reach of immunity is being considered, advocate immunity doesn't really feature in the cases. Indeed, although the judge identified a sixth category in his list of advocates' immunity before court, he doesn't refer to it in his ruling. following the attenuation of immunity for an advocate or then a barrister, initially in Saif Ali, and then, of course, in J.S. Hall, vis-a-vis the advocate's own client, it's not that surprising that it doesn't feature, because it is always going to be about what is said or done in court. And when the penumbral reach of immunity generally is being considered in the cases, and indeed by the judge, in our submission, within his designations, what is really being talked about is either witness immunity and the reach of that, and whether that is needed, the reach of it is needed to avoid the immunity being outflanked, or judicial proceedings before court immunity. We submit, however, that what the judge did was to import into advocate immunity, in his designation, advocate's immunity at court, part of the analysis process and concepts that are useful for that penumbral reach into advocate immunity, where in our submission they do not belong. Can I go a little further back even than we have gone in the case law already, very briefly at the outset, to Cutler and Dixon, which you'll find at tab 3 in the authorities bundle. Very, very short report.
This is the case reported the same year as Mary Queen of Scots was executed.
It's certainly quite an old case, my lord. And it's useful to have that historical reference. It contains a pithy, in our submission, phrase capturing the rationale of the immunity. Page 66, 5 lines from the top, above the line. If actions should be permitted over the page in such cases, those who have just cause for complaint would not dare to complain for fear of infinite vexation. And back to page 66 now, below the line, about 8 or 9 lines down, it's recorded that the reason of this is obvious, because the courts of justice and the Great Council of State are the constitutional tribunals to which grievances should be preferred, and to bring alleged wrongs under their notice is to support and not to break the peace. Skipping a few words, this privilege extends to the parties, counsel and witnesses in a cause, provided the allegation be pertinent to the matters in issue. In our submission, the reason it's obvious is, to borrow a more modern phrase, if it were not for the immunity, there would be a chilling effect upon proper complaints being brought within the administration of justice and being properly defended.
Well, there's a further aspect, which is the implications for the decision of the court if collateral attacks are made on witnesses for
Yes.
things said or done, which the court may have adjudicated upon.
Indeed, my lady, that's, as you rightly allude to, one of the themes in the cases, particularly, I would submit, in relation to the witness immunity. And all of these immunities are part of one core rationale, which has various features, that is certainly one. But it's going to be part of our submissions that they are not the same. And it's in that context that I take the risk of returning to Munster and Lamb, to which you have already been referred more than once. And can I just therefore highlight that from the headnote, the very end of the headnote, the allegation in question about the owner of the house, a barrister as it happens, potentially having had drugs on the premises for immoral purposes, put in order to try and deal with the suggestion that the occupants had been drugged so as to effect the burglary, was without any evidence. And then, as you have already had your attention invited to, it was in the judgment of Lord Brett, Master of the Rolls, clear that he, and indeed the court, took the case as if there was no foundation for what was put in court. That is, he took it that page 100, in the middle, they were spoken maliciously, without any justification or excuse, and that they were irrelevant. Nonetheless, he said, because they were uttered in judicial inquiry, use his words, no suit lay. And this illustrates, we submit, that from the very outset of its early development, advocate immunity has applied so as to cover even what would otherwise have been a manifestly legitimate suit. As we put it in our written application, the cost to those who have been wronged has been baked in, or in slightly less exotic language, taken into account. Indeed, according to Lord Brett, we submit, at the bottom of page 101, this was the ratio of the case. 5 lines up, it was contended that an advocate cannot claim the benefit of the privilege unless he acts bona fide, that is, for the purpose of doing his duty as an advocate, and unless what he says is relevant. That is the question which we now have to determine. And again, you've had your attention taken to pages 104 and 105. So might I just extract a small portion of page 105, 4 lines down. If amidst the difficulties of his position, he were called upon during the heat of his argument to consider whether what he says is true or false, whether what he says is relevant or irrelevant, he would have his mind so embarrassed that he could not do the duty which he is called upon to perform. And so it is, just over halfway down, a passage already referred to, that the immunity is made, to use his words, so large that counsel are included who have been guilty of malice and misconduct. Only by making it so large does the chilling effect of the fear of vexatious litigation be avoided. This is to the same effect as the often cited passage of Lord Justice Fry further on at page 108, which features frequently in the later cases. And again, you've had your attention taken to it. And it's the same rationale that persists and was referred to by Miss Barton in Metcalfe and Mardell for your note at page 531E, paragraphs 51 to 54. that aspect, that particular aspect of the rationale applies most powerfully, we submit, to advocate immunity in the judge's designation at court. But to illustrate my submission that the different aspects of immunity, the different categories, if that's not pushing the distinction too far, is illustrated by, again, an authority you've had your attention taken to, Darker, and it's at page 337, the authority starting at 316. Between D and E, immunity has in the past been recognised in respect of the judge, the jurors, the advocates, the witnesses, and the parties themselves, at least within the confines of the court proceedings. But since it may be that distinct considerations may apply to some or all of the other four groups, it's proper to restrict the present discussion in Darker to the immunity of witnesses. And we highlight that because the analysis of Darker was relied upon by the judge, and we shall submit shortly, found its way inappropriately into his analysis of advocate immunity.
Mr. Waterman, I don't want to cut you off, this is very helpful, but I am conscious of the purpose of an intervener's role, which is really not to make submissions of law that could be made by other legal teams who are here, but really to focus in particular on the Bar Council's particular interest or concerns for consequences for the profession one way or another. I'm sure you've got that well in mind. It certainly comes through both the evidence of Dr. Van Dellen and your helpful written submissions, but just do bear that in mind.
I will. That's very helpful, my lady. The reason for addressing this is because, in the way that I am, is because when we come to the judge's ruling, it is the consequences of his ruling of importing the idea of evidence into the test.
Thank you. So
that's the reason for it. It's not to argue for one side or the other, as it were, in the matter before you.
So the short point is you say Darker's not concerned with an advocate's immunity.
It's not concerned with advocate immunity. It's about witness immunity and the penumbra of reach. And so at 335 G to H, for example, the concept of the functional test is referred to by First Lord Cook at G to H. In what he says is this difficult field, there have been line drawing differences. And Lord Clyde similarly refers to the functional approach. But we submit that's in the context of witness immunity, not the subject of our submissions and, as it were, interest, namely advocate immunity. Can I then address briefly the limited effect of Hall and Simons as far as that all-important, from the Bar Council's point of view, advocate immunity? Their lordships addressed, and I'm not going to go through them in any way at all, the four justifications for put forward for advocates' immunity, and they're in the head note at page 372A. Cab rank rule, analogy with immunities of witnesses and others involved in legal proceedings, the duty of the advocate, and the public policy, as my lady highlighted a few minutes ago, against relitigating. None of those, as we of course know, was sufficient to justify the retention of the immunity. What did not cause any difficulty in Hall was the issue of what I shall call the freedom to speak freely, the undergirding rationale for advocate immunity. And this is the practical effect that we seek to, as it were, highlight the need for. At page 435, B to C, and then at E, Lord Hoffman there makes plain that this, my expression, not his, the freedom to speak freely is what is so essential for an advocate to discharge her or his duty.
Sorry, at 435
435,
is Lord Stein.
I'm at the wrong page. You're quite right, my lord. It is Lord Stein, and it's B to C.
Yeah.
And he goes on to say, at C, as Panic has pointed out, that underlying rationale, the freedom to speak freely, my phrase, has little or anything to do with the alleged legal policy which requires immunity from actions for negligent acts. And that was dealt with at greater length. I was ahead of myself at 453 by Lord Hoffman, who at E to F criticises Lord Diplock for saying the rationale of to ensure that trials are conducted without avoidable stress and tensions or of alarm and fear in those who have a part to play in them is, I'm going to tone down the language, too broad. And the logic of that, we submit, is leads into what is said at E over the page at 454. A witness owes no duty of care to anyone in respect of the evidence he gives to the court. His only duty is to tell the truth. There seems to me no analogy with the position of a lawyer who owes a duty of care to his client. And so the rationale for the abolition in Hall had nothing to say about the rationale for advocate immunity as against the opponent of the advocate or the advocate's lay client or third parties. Because in Hall, an essential point was the advocate owes the duty to his client, and this is where, as it were, the rubber hits the road for an advocate.
Is this paragraph 40 of your skeleton argument?
Yes, my lady. Yes. I didn't catch what my lady was saying about paragraph 40. I'm sorry.
No, that's all. Was this paragraph 40 of your skeleton?
I'm so sorry.
Yes.
It is, yes. And indeed, that very point that I have just made is made by Mr. Justice Fancourt in Al Hadid at page 1576 and paragraph 90. The exception to the immunity rule doesn't detract from the immunity that the same advocate has to a claim by his client's opponents to whom he owed no duty of care. And that same logic, of course, carried over into Jones and Caney as far as expert witnesses are concerned, but we make the submission that the duty that an advocate has to her or his lay client requires the immunity to a greater extent even than an expert witness. Because, as I have already rehearsed from the authorities, the advocate cannot practically test the truth or falseness, the reliability, the relevance of things that they are, as part of their duty to their lay client, going to put by way of argument or cross-examination or speech. That same page in El Haddad, Mr. Justice Fancourt says, subject to, at paragraphs 43 to 44, subject to the overriding duty to the court, the lawyer's duty is to present the facts as their client alleges them to be and advance arguments based on those facts. Importantly, for present purposes, a lawyer doesn't owe the court or another party to the case any duty to investigate the facts or ascertain the truth before advancing the factual case on behalf of their client. So this essential advocate duty is fundamental not to protect the advocate, but to further the interests of justice in judicial proceedings. That brings me to the fact that Mr. Justice Ritchie, in his ruling, perhaps I can take it shortly and go straight to paragraph 113. Which is page 200 in the bundle.
Yes.
Where he's dealing whether the advocate's immunity covers the CPS and should it have been granted. And he concludes, in my judgment, at least arguably, the core part of advocate's immunity AC relates to the witness evidence in the case, not to extraneous or peripheral or administrative matters. There's no previous decision on the same facts. So acknowledging that this is novel, and that conclusion begins its life earlier in his ruling, when at, for example, page 177, he rehearses part of a passage from Darker, in particular Lord Clyde, but the other judges, in particular Lord Cook, make similar points, importing from US jurisprudence the distinction of function versus evidence. And then in the middle of the page, he says, on the basis of this ruling, no immunity attaches to actions which do not form part of the evidence to be given at trial. The bail hearing file prepared by the police was arguably extraneous. There, of course, he is referring to the police, and that aspect of his ruling flows from Darker's analysis of witness immunity. But can I go then, please, to paragraph 105 at page 196? Two lines down. When considering the immunities which I've labelled and listed above, the appellate courts have arguably stated that the correct approach to claimed immunities beyond the core ones, and then he lists them in parenthesis, witness immunity AC, judge's immunity AC, and parts of advocate's immunity AC relating to the evidence in the case. In our submission, that aspect of the qualification he introduces to advocate immunity has carried over from his analysis of witness immunity, and it introduces for an advocate the uncertainty that lies at the core, in the essence of why the immunity allows the advocate to perform their role in the justice system, and in particular allows them to be free to speak freely. And it is the fear of an opponent or a third party taking umbrage at what was said as part of the advocate's duty that we submit is the harm that would flow from an advocate having to assess where the boundary lay and the chilling effect that that would have upon an advocate discharging her or his duty. And in our submission, that self-evidently impinges very heavily upon advocates at any hearing. And the distinctions about bail hearing or trial are, as far as that is concerned, immaterial. Finishing that, therefore, by returning to the core rationale, it isn't to protect members of the bar or solicitor advocates that the immunity exists, and it isn't to protect those advocates that we submit that it is essential to the running of the administration of justice. It's because that very system of justice can't function as it should without that immunity being, to use the expression that's been used by others, absolute. That's all of my submissions. The practical effect is intrinsic to the analysis that I brought to bear, I hope. I'm now going to ask Ms. Collier to make some submissions about the importance and practical effect in the more modern era of the Data Protection Act and the Human Rights Act, and the wider reach that those provisions give rise to.
Thank you very much indeed, Mr. Waterman. Questions, Peter? No. Thank you very much indeed. Yes, Ms. Collier.
My lord, my ladies, the core submission that I intend to make is that there are various features of the way in which Human Rights Act claims and Data Protection Act claims operate, which mean that exposure to such claims would have a particularly inhibiting effect on an advocate's ability to discharge their duty to their client and their duty to the court. But before that, I want to briefly look at the authorities as far as they concern the scope of the immunity as regards Human Rights Act and Data Protection Act claims. There is no clear and developed discussion in the authorities that directly addresses the question of whether advocate immunity covers claims brought under the HRA and the DPA. A number of cases have determined that where the immunity applies, the immunity is not restricted to claims brought in defamation. Ms. Barton has taken you to many of those earlier today. In addition to the examples given by Ms. Barton, I would also like to draw to the court's attention a further passage in Marinan against Vibert, tab 8, page 121 of the authorities bundle. And the citation that I wish to draw to the court's attention is found at page 131.
Yes.
There dismissed the argument that the public policy reasons for the immunity, which in that case was witness immunity, applied only to actions in defamation. This is perhaps one of the passages that my lady had in mind using the word ingenious. The court said, in its well-read bar, Mr. Lewis has sought to persuade this court that the rule of public policy, for reasons which it's impossible to explain, applies only to actions for defamation, and that if you're sufficiently ingenious to discover some other way of bringing an action against a witness for evidence which he has given in court, then the rule of public policy does not apply to that, although all the evils of the action are precisely the same as if it were an action for defamation. Then an authority which I don't believe Ms. Barton cited to you, Reading Borough Council versus Singh.
Yes, that was mentioned.
It was mentioned, tab 31, page 807, where at page 810, Lord Justice Lewison expressly described the practice of bringing a claim based on a cause of action other than defamation as an attempt by litigants to, as he said, outflank the rule.
Sorry, Ms. Collier, can you just give me the reference, the paragraph reference? I've got the case.
The paragraph reference is paragraph 28.
Thank you.
These cases, therefore, state that where, as far as witness immunity exists, for it to fulfill its function, it must operate to exclude not just actions in defamation, but claims brought under using other causes of action as well. And we submit that the reasoning which led to that conclusion in these cases applies to advocate immunity as well. Turning then to two cases which did explicitly involve claims brought under the Human Rights Act and or the Data Protection Act. Neither of them provide a particularly extensive analysis of how the immunity might either operate to exclude or not those causes of action. The first of those is Smart against Forensic Science Service, which is tab 30 of the authorities bundle, starting at page 783. The claim there being brought in negligence and for breach of Article 8 of the Human Rights Act. The claim there, the brief summary of the facts was that the claim was brought by someone who had pleaded guilty to an offence of possessing live ammunition, based on, and the guilty plea was based on the report provided by the Forensic Science Service. It was then later discovered that the piece of ammunition in question had there'd been a muddle and possibly a cover-up of a muddle, with the result that actually the Mr. Smart's ammunition had in fact not been live ammunition, hence his claim in negligence and for breach of Article 8. Lord Justice Moses said at paragraph 32, it is unlikely that the Human Rights Act claim will need resolution, though he did not explicitly state his reasons for this observation. Lord Justice Aikins, at paragraph 38, said that the key issue, assuming that there is no immunity, in brackets, is whether the Forensic Science Service is a public body or not, thus suggesting that he may have thought that were the immunity to operate, it would operate to exclude the Human Rights Act claim as well as the negligence claim. The second of the two authorities, my lord, my ladies, that I wish to draw to your attention is CLG against the Chief Constable of Merseyside Police, to which you have already been taken today. Tab 35, page 905, which was an appeal from the judgment of the first instance judge following a 3-day contested trial. The Court of Appeal found that the actions of the officer in sharing the claimant informer's addresses with the CPS within a witness statement, which then led to the subsequent disclosure, was within the scope of the immunity afforded to witnesses in legal proceedings, and for that reason, the claim in negligence was barred. The Court of Appeal did, however, go on to determine the appeal on the Human Rights Act and Data Protection Act claims on the merits, as had the judge below. It appears from the report of that case that the police were the sole defendant, as I think my lord observed earlier. Moreover, it is in our submission not completely clear from the report of the case whether it was argued that the HRA and DPA claims were, in addition to the negligence claim, barred by virtue of the immunity. Paragraph 25 of that judgment at page 913 suggests that witness immunity was only advanced by the police as a defence to the negligence claim. In any event, the Court of Appeal appears to have accepted that witness immunity did not cover the Data Protection Act and Human Rights Act claims and address them on their substantive merits. We would submit, for the reasons that I'll come to shortly, that where the immunity applies, the statements of Lord Justice Diplock in Marinan and of Lord Justice Lewison in Singh are to be preferred, and that advocate immunity covers the Data Protection Act and Human Rights Act claims as well as defamation claims for the reasons that my learned friend Mr. Waterman has just outlined. If I can come on now to some reasons why we suggest that, in fact, the core principle in the good, that's to say the protection of the good administration of justice that has been outlined by Mr. Waterman is in fact even more important in the context of today's 2025 world, in the context of claims brought under the Human Rights Act and under the Data Protection Act. To adapt the words of Lord Steyn in Hall, the world has changed since 2000, when that case was decided. The legal landscape today is significantly different. When the House of Lords delivered judgment in Hall in July of 2000, the Human Rights Act had not yet come into force. It's October 2000. Since then, it has become embedded as part of our domestic jurisprudence, and both the general concept of human rights and the specific rights protected by the Convention are, we suggest, familiar to the general public. Meanwhile, in a parallel development over the same 25-year period, data and data protection has acquired a prominence that it simply didn't have in the year 2000, with most people recognising they have data rights only through clicking consent boxes several times a day. And we say that it's important to take account of the way in which society and the legal landscape has changed since 2000 when considering the reach and effect of advocates' immunity. We said there are various features of the way in which, in particular, for the purposes of my submissions, the Rights Act and Data Protection Act claims operate, which mean that exposure to such claims would have a particularly inhibiting effect on advocates' ability to discharge their duties. I should say, for the purposes of this section of my submissions, that we do of course note that an HRA claim could only be brought against a public authority, which in this case, because the advocate was a CPS advocate, that was viable. And otherwise, there would be a question to be resolved, as we see in Smart against Forensic Science Service. Assuming that the Human Rights Act does apply, there are three reasons why, in contrast perhaps to the year 2000, the risk for advocates of being exposed to such claims is greater, and therefore the importance of the immunity remains. Firstly, a cause of action is likely to be generated in this context, i.e. advocate immunity in court, simply by the advocates speaking. Spontaneous verbal expression in court is therefore theoretically capable of being threshold for a cause of action under each of these statutes, under the DPA and under the HRA. We would submit that this low threshold for generating a cause of action is an important factor to be taken into account when considering how likely and or how significant a problem vexatious claims brought against advocates may be. And I would suggest that the distinction is there to be drawn between causes of action which may be generated from spontaneous speech in court and some of the other examples that we see in the authorities examining the ambit of the immunity outside court. So, for example, advice given or failure to identify a correct defendant. There's a distinction in our submission, it's a very important one, between those sorts of actions which have been the subject of previous cases and the sorts of actions which may be generated if the advocate immunity in court does not exclude actions brought under the DPA and the HRA and indeed the tort claim, misuse of private information. Second, potential claimants for such claims are not just limited to the advocate's client, but to any third party whose personal data might feature during court proceedings. Some examples of when that might occur are given in Dr. Van Dellen's witness statement at paragraph 30, which is at page 50 of the Bar Council bundle. Just briefly take you to that paragraph, if you have the, my ladies, the Bar Council bundle.
Yes.
At page 50, paragraph 30 of Dr. Van Dellen's statement, in fact, there is explicitly dealing with the practical problems that may be expected to arise should Mr. Justice Ritchie's distinction between evidential and administrative be held to be critical to the operation or not of the immunity. But in my submission, and some examples are given there, which we would ask you to take account of. But for the purposes of my submission right now, at little a and little c, we see examples of cases where it can readily be seen, we suggest, that what I would call sensitive data, personal data, it is likely to be the subject of submissions or questions and answers as between court and counsel. A, in public law children's cases, and then C, in all proceedings where, for example, the witness availability is being discussed. The point that I wish to make, my ladies, my lord, is that every day, up and down the country, advocates are required to speak in court spontaneously in ways which are likely to involve, and expressly will involve, data, information that could well be capable of founding a claim for breach of the Data Protection Act or under Article 8, or breach of Article 8.
Right. Yes.
Thirdly, unlike the tort of negligence, where it has been said, for example, page 438, Lord Stain in Hall, tab 19, unlike the tort of negligence, where it has been said that any negligence claim brought against an advocate, in any negligence claim brought against an advocate, the court would readily distinguish between errors of judgment and truly negligent conduct. In claims brought pursuant to the HRA and the DPA, there is no such margin which allows there to be a distinction drawn between words that are spoken that are mere errors and words which attract liability. Mere errors that don't result in liability and words spoken which attract liability. It follows in our submission that if advocates at court do not have immunity from claims brought under the HRA or DPA, they will be at risk of exposure to claims from a class of claimants which is certainly wider and arguably less predictable than in the case of negligence claims from their own clients, and on the basis of a lower threshold of words spoken in court. Lord Hobhouse observed in Hall, the reference being tab 19, page 493, E to F, as regards the various reasons of public policy that had been advanced justifying the recognition of an immunity. He said, some factors which seemed important 30 years ago have ceased to be so now, and others, which received only a passing reference then, can now be seen to be essential in making the right evaluation of where the public interest lies. Likewise, in conducting a re-examination of the cogency of the various factors, it is necessary to set them in the appropriate current context. we submit in the current context to which I alluded earlier, we submit that the current context to which I alluded earlier has brought back into sharp focus the public interest in advocates who are being engaged in litigation, being able to speak freely without fear of liability. And that it is necessary for the good administration of justice. Unless I can assist you further, those are my submissions.
No, obviously, speaking for myself, there is a lot of material in Dr. Van Dellen's witness statement about issues facing the profession. We're to take those as read, are we?
Yes, please.
Anything you'd like to ask?
I mean, I'm just interested in CLG because it's clear that the Judge Woods, did consider whether the immunity covered, in other words, the judge that the judgment of the Court of Appeal was dealing with did consider whether data protection, the immunity covered the claims under the Human Rights Act and the Data Protection Act, and decided it didn't. But there's no part of the that I can find of the decision of CLG which expressly explains whether the Court of Appeal considered that issue at all, or whether it's a subject of an appeal. It was simply dealt with as a discrete issue under Article 8, the Data Protection Act.
My lady, yes, I agree.
We don't get any more help from that authority than that.
No, not as far as I
It
can
doesn't actually
discern.
address it to consider it or dismiss it.
Sorry, I didn't.
It doesn't address it to either consider it or dismiss it.
I would agree, my lady, respectfully, that it appears to have dealt with the appeal in exactly the way that the court below did. I couldn't discern from it any assistance as to the reasons for that. But as it is perhaps the only authority that covers specifically the DPA and the HRA, it seemed important to bring it to your attention.
No, absolutely. Thank you. Peter, got any questions?
I haven't. Thank you very much.
Thank you very much indeed. Thank you very much indeed, Ms. Collier. Thank you, Mr. Waterman, as well. That is a useful moment for us to stop. Thank you all for your hard work and excellent submissions on all sides today. And Ms. Murphy, we look forward very much to your submissions tomorrow morning. We are on course, I think, for a 10:30 start. We've got time available, and if we can complete in less than the full day, then that would be welcome to all, I'm sure. Mr. Waterman, Ms. Collier, if you don't wish to attend tomorrow, please, that will be not be taken as any sign of disrespect. It's entirely a matter for you and your clients.
Might try and find a cooler room, Melody.
Yes. Ms. Murphy, anything you'd like to raise with us at this stage? Just 10:30 tomorrow?
No, my lady, we will pick matters up tomorrow morning.
Very good.
Thank you.
Thank you all very much. 10:30 tomorrow.